People versus Watkins.
Good afternoon, and may it please the court. Elizabeth Vasily on behalf of appellant Mr. Mark Watkins. I'd like to request 5 minutes for rebuttal.
Yes.
In this rare single witness identification case with absolutely no other corroboration, trial counsel failed to request a cross-race ID charge, which would have informed the jury that people may, quote, have a greater difficulty in accurately identifying members of a different race.
At the time of Mr. Watkins' trial, had the law been settled that he was in fact entitled to the charge?
Your Honor, Boone had not yet been decided at the time of the trial, but the charge was in the criminal jury instructions, the model instructions, and they had been there for 6 years prior to the trial. It was also recommended by the ABA, by the New York State Task Force.
So your claim is that even under the laws that existed at the time, it was ineffective not to at least request the charge?
Yes, Your Honor.
Well, you say Boone had not been decided, but Boone had been argued, no?
It had.
Hadn't it already been published for re-argument?
It had, Your Honor. And of course,
Okay.
attorneys have a responsibility to keep abreast of developments in the law. But even so, Boone being decided, it merely gold-starred or rubber-stamped a practice that should have
Boone
already...
doesn't make it mandatory, does it?
It makes it mandatory upon request.
Upon request, but it does leave it, as I read Boone, tell me if you have a different view, up to the choice of defense counsel or perhaps the prosecution to request, yes?
It does, Your Honor.
And so the point here you're saying is that to not have requested it is ineffective assistance, even though even post-Boone, defense counsel could make a choice not to request for strategic reasons, yes?
Yes, Your Honor. In the ineffective assistance of counsel...
Sorry, what could possibly be strategic reasons?
There were no
In your
strategic
case.
reasons.
In your case.
There would be no strategic reason, Your Honor, for not requesting such a powerful charge that went directly to the core of the defense
So
theory.
then how does Boone, if it were to apply, if we were to say because it was re-argued or argued or accepted for a leave grant, how would the Boone potential decision, how would Boone affect that analysis, the ineffectiveness in this case?
Well, in this case, it would affect the prejudice, for one, given that prejudice is determined now at the time of the ineffective assistance of counsel claim. But even so, it would also affect deficient performance, one, in the way that Judge Rivera mentioned.
My question isn't clear, I apologize. Under Boone, if you ask, you get. Under the law before Boone, it was discretionary call, and in fact, the appellate divisions were upholding the exercise of that discretion. So what would the effect of it not being discretionary upon request be on the ineffective analysis?
A lot of mistakes that defense counsels make that are found ineffective are failing to ask for discretionary things from trial judges.
Right.
And in this case, this was such a powerful charge, even at the time, even pre-Boone. And Boone didn't create some new obscure law that nobody could think would ever come into existence.
What cases can you point us to that are most like this one, where there is a discretionary charge to which, under the law at the time, the defendant did not have an entitlement? As Judge Garcia said, the appellate division was sustaining the denial of the charge, and that the failure to ask for that was deemed ineffective. What cases are most analogous, would you say, from our court to that circumstance?
It would be any case such as DeBellis or any other cases where a trial counsel was found ineffective for not asking for something that would be in the judge's discretion that would be so powerful.
Do you think that this is so clear-cut and dispositive that Turner would apply on a charge that isn't even mandatory? What's your argument that it was so clear-cut and dispositive?
It's certainly clear-cut and dispositive, Your Honor, because it was in the model jury instructions. It was recommended, it was widely used by defense attorneys at the time. And it's dispositive because it would have injected doubt and could have easily tipped the scales in the favor of acquittal.
But how do you know you would have gotten it if it was a discretionary call at the time and they were routinely upholding the exercise of discretion, how can it be dispositive if it's not so clear-cut you would have gotten the charge in the first place?
First of all, Your Honor, the burden is not that we have to prove that the charge would have assuredly been granted. Under the federal standard, it's only a reasonable probability that the charge would have been granted. And New York's even lower than that. If anything, the judge granted the one witness ID charge. It would have every reason to grant the cross-race charge as well.
So are you arguing essentially here that because of the nature of the case, where identification was everything, the attorney should have been educated with respect to the issue and possible defenses, and including proper instructions to request of the court, whether they be granted or not?
Absolutely, Your Honor. In this case, with no corroboration, to have the jury consider cross-race ID and the unreliability of that in the mix would amplify all these other
Why
reasons to
isn't
doubt.
this Blake? I think Blake, we said it couldn't be ineffective assistance of counsel because the entitlement to an adverse inference charge was not conclusively established until 2013. At the time of the defendant's trial, the availability of the charge was discretionary. Why isn't this Blake?
Blake was very different, Your Honor, because this court determined that on prejudice, and in that case, there were a lot of facts that went directly against that adverse influence charge. In Blake, the defendant tried to bribe police officers into destroying the video that would have been subject to such an adverse inference charge.
Well, we said if it was a mistake, though, right? Even if it was a mistake.
And this is a lot more powerful to go to the heart of a defense theory and something in the CJI for 2011. There was no CJI for the adverse
Can I
inference
ask you to go-
charges for Rosario.
Can I ask you to go back to your comment that the charge clearly would have been granted? I thought in Boone, but maybe I'm mistaken, that there was an expanded witness charge granted, but the cross-racial ID charge was not granted. Is that right?
That's correct.
Okay, and so the appellate division upheld that, and it's certainly right that the case was before this court at the time of your client's trial, but Boone itself seems to me to be an example of a case where the expanded witness charge was granted, but the cross-racial wasn't. And so why was it so certain that if requested, the result would have been that the charge would have been granted as opposed to what happened in Boone itself, where it was not granted?
Defense attorneys would still want to request these charges because they start with the CJI. They look at the model instructions. Just because an appellate division decision and Boone decided against granting that charge, courts do that all the time. Courts find no abuse of
Doesn't it
discretion.
make it hard to say it would have been certainly granted? I guess that's what I'm asking.
That's not the standard that it be certainly granted, but there's a very high likelihood that the judge, in its discretion, would have granted the charge.
But isn't the point that leave was granted and it was re-argued, so obviously the court was going in a particular direction, uncertain, but it could have been in direction favorable to the defendant. And by not requesting the charge, you've potentially, as is argued here, forfeited an appealable issue.
Absolutely, Your Honor. That it was pending as well was very persuasive, in addition to the fact.
Can I ask you a different kind of question, though? I'm just curious, because I see this in the briefing. Boone was very clear that it was only about cross-racial identification, but this involves a Latino witness. So could you tell me whether or not that at all affects the analysis?
That what affects it, Your Honor?
That the victim, the witness who testifies, but it's a victim, was Latino. Since Latinos apparently can be of any race or no race.
Your Honor, it's undisputed in this case that they were of different races.
Okay, I'm asking you, how is that undisputed? I couldn't find anything in the trial record about the victim's race.
In the record, Your Honor, the police officer does talk about the races of the two, of the suspect. I believe it's at A237 and A31. They discuss that they're of different races that.
Based on what? Because he's Latino?
Based on the pedigree information in the case.
But does the pedigree information say anything other than Latino?
It says.
Hispanic?
It says Hispanic, and then there was a debate about whether the defendant or the complainant were black, and they said that the defendant was black, but that the complainant was not black.
Yeah,
I'm sorry, and that, just to clarify, that's at A237 and A31. I can find what you've just described on either or both of those pages.
What I just said was in the suppression hearing, but it's also in those records as well.
So I'd appreciate your thoughts on the posture here. So we're in direct appeal, right? And post-Boone, it seems to me that because there is discretion given to trial counsel as to whether to request or not, you would have to figure out what circumstances there would be an ineffective assistance claim that would lie on direct appeal versus on a 440, right? And so setting aside the fact that we're pre-Boone and not post-Boone, how would you have us sort that out? You're arguing here that even pre-Boone, we can resolve this on direct appeal. I'm wondering how we do it post-Boone. Do you have a view on that?
Either way, Your
On
Honor.
a direct appeal as opposed to 440, I mean.
Either way, Your Honor, because there's no conceivable reason to not request this charge.
So is that what we have to do? We have to look at the record in a particular case and assess whether we think there is any possible strategic consideration that might be apparent from the record, and that's what determines whether it's direct appeal or 440?
That's correct, Your Honor. And in the facts of this case, with such a weak ID, with no other corroboration, there would be no strategy behind not requesting this charge. And so even on direct appeal, that's appropriate.
Let me ask you one thing related to that. So do you have a sense, pre-Boone, in single witness identification cases where there's nothing other than that ID, what the track record for requests for a cross-racial ID was?
I don't, Your Honor. But it was a practice that was ongoing, and Boone gold starred it. It rubber stamped it. It didn't create this new law that a lawyer would have no idea was going to go into formation,
Well, it did
months
in
after
that the
trial.
appellate divisions, I think, had a different view. I mean, in that regard, it created new law by making it mandatory upon request, right?
It made it mandatory upon request. So it would be just like if this court decided that a certain Molyneux conviction had to be mandatorily precluded today. But that doesn't mean defense attorneys shouldn't have been requesting it for years and years prior and couldn't be ineffective for failing to ask for
And
something.
that at the time of, well, actually, by the time Boone is granted leave, there were other jurisdictions that had already adopted this charge, including mandatory.
Yes, Your Honor. It
Correct.
was mandatory in New Jersey as well as Massachusetts and Hawaii.
Well, are you concerned at all about the implications of finding an attorney ineffective and all that goes with that in their entire career at a time when Boone had not even been decided?
In a
Is that
case,
something that we should be concerned about?
Your Honor, in a case that has this much risk for wrongful conviction and misidentification, a lawyer should be asking for that charge. Boone or no Boone, this was in the CJI since 2011. Trial took place in 2017. For 6 years, this was common practice. And when you have
So is
no other
it your
corroboration.
argument that because ID was central to the case, the attorney, in order to be an effective attorney, at a minimum, needed to know at least possible options in order to present a defense at trial, and appropriate instructions, that they should be aware of instructions? Is there any indication here that the attorney knew that it was a part of the CJI? Or does
That's-
it matter?
That's right, Your Honor. And it doesn't matter because the lawyer should have known that he should have requested it. It was in the CJI, and whether he just made a mistake, because it seems almost illogical to request the one witness charge and all those factors and just forget to include the cross race, or whether he had some reason that doesn't even matter what it is. Either way, nothing could be reasonable given how problematic this ID was, how
Counsel,
weak this.
I want to go back to Judge Singus's question. So if we're going to find an ineffectiveness here with respect to Boone, Where would you draw the line? Would you draw the line when the court grants leave on the issue? Would you draw the line when the court hears argument, or would you draw the line when it's re-argued? When would a lawyer become ineffective for not realizing the situation with respect to the appeal?
In any of those situations, Your Honor, but here we don't even need to
No,
go
but I'd like to know
there.
how you think the court for the next case should approach this. Should we say once leave is granted, any attorney who's practicing as a 1ID case, they should have known? Should we say once it's argued and you can listen to the tape of us asking questions, then the lawyer's ineffective for not doing it? Or should it be it has to be re-argued so they know that there are at least some judges on each side of that issue? And again, going to Judge Singer's, is when do we label a licensed lawyer ineffective for not doing that?
When leave has been granted, I believe in dicta, this court has said that that's something that lawyers should keep track of. But in this case, Your Honor, that's not
So
even.
the rule, though, that you would ask for would be once leave is granted? Do you think that's the rule we should apply?
No, Your Honor, I'm not asking for a rule today, and this court need not adopt a rule to decide Mr. Watkins' fact-specific
But
case.
whatever we decide will certainly have consequences down the road, right?
Not necessarily, Your Honor, because here the cross-race charge had been in the CJI for 6 years. Boone really is irrelevant at the time because it's something that should have been asked for, Boone or no Boone. So whether leave had been granted in
So are you essentially
Boone.
arguing that it's basic information that a competent attorney should have been aware of?
Absolutely, Your Honor. It's in the model jury instructions. It's in other nearby states. The ABA is recommending it. It's in the New York State Task Force. It goes to the heart of this defense theory in a case that has a lot of other problems. And so,
May I ask, the trial attorney, the defense attorney we're talking about, were they a private counsel or were they one of the institutional defense offices
he was
counsel? Do
an
you know?
18B attorney, I believe, Your Honor.
Thank you.
And in this case, with no video that you could see a face, it was blurry, no confessions, no fingerprints, no forensic. There was this perceived familiarity, this risk of unconscious transference. He said he thought he saw Mr. Watkins around. He was hit in the eye with a brick and was dizzy. He was viewing the suspect from 15 to 20 feet away. All of these factors, if the jury had had a cross-race identification charge, would have amplified each other and would have only made the jury look at all these other reasons to doubt with a cross-race lens as well. And Mr. Watkins was deprived of that charge at his trial and is now serving 13 years in prison. And for that reason, a new trial is required, but I have the rest of my time at rebuttal.
Thank you.
Good afternoon. May it please the court, Michael Yetter for the people.
Counsel, what's the possible strategic reason for not requesting the charge here?
Well, first of all, Your Honor, it's not my burden to demonstrate that there is one. It's my opponent's burden to demonstrate that there is none. But I
Okay.
think, counsel raised many issues and got the expanded identification charge. Counsel could have been thinking, I want the jury to focus on a couple of these factors that are known to implicate ID, but I don't want them to get confused. I want them to be focused. And that's certainly a legitimate or strategic reason not to request a charge.
But nothing tied specifically to the facts as
Well,
they were presented?
In this case, Your Honor, here's what we do know. This victim was born in the Dominican Republic and lived there for approximately 38 years. The victim subsequently moved to East Harlem, where the victim lived for 24 years. And he had worked at 3 buildings on East 103rd Street for approximately 11 years.
What does that
before
have
his
to
death.
do with cross-racial identification?
Well, one of the things that the charge talks about is the interactions or opportunities to interact with people of the identified person's race. That's what the 2011 charge talks about. And counsel may have thought that given that background, this victim had ample opportunity to interact with people of the defendant's race and therefore chose not to.
What is in the record that demonstrates that there was that opportunity or actual interaction with persons of the opposite or different races, other
It's-
than where he lived and worked?
It is the testimony I just described, specifically with respect to this case. You have the additional identification procedures that the police
But
went
isn't
through.
it true that sometimes people may cursorily interact, but that interaction is not sufficient, that it would alleviate the concerns raised by cross-racial identification?
It's possible, Your Honor, but the record was not expanded on this point, so I don't think we can say that the absence of evidence shows that counsel.
Should a competent attorney be aware of charges that are available to be considered in a trial, especially identification, when identification is everything?
Of course, Your Honor, and there's no indication in this record that this attorney was not aware of the availability of this charge.
Counsel, are you as certain as your adversary is that the witness and the defendant were of different races?
We know, I think if you looked at the pictures that are in evidence, Your Honor, that they look different in terms of skin tone. The victim testified that he was born in the Dominican Republic. I believe the defendant's photo is in the appendix. I'm not sure if the victim's photo, but it was entered into evidence at trial. All I can say is they look different. I don't know.
So do you dispute that the races were different?
We're not disputing that the charge was available in this case. And I think if under a Boone regime, I think we would have a hard time convincing a court
So
that.
post-Boone, do you have a sense of how frequently defense counsel, in a case where they would be entitled to a cross-racial charge, is not asking for it?
Like my counsel, Your Honor, I don't have statistics on that.
Even impressionistically, I mean, have you countered that at all?
I haven't personally, Your Honor, but I also haven't tried very many cases, so
Fair enough.
I don't know for sure.
And do you know the answer to the Chief's question to your adversary about how frequently the appellate divisions were either granting or denying the charge prior to Boone, either anecdotally or statistically, either way?
Anecdotally, I think they were evaluating it under the Wayland Knight standard, which is, yes, it might be recommended, but it's ultimately up to the trial court's discretion. I believe we cite 3 cases in our brief where the First Department had upheld and affirmed those exercises of discretion.
Do you agree with opposing counsel that post-Boone, at least some cases can be decided, ineffective assistance cases, on direct appeal as opposed to a 440? Or do you think that there's always a 440 required to assess if there's a strategic consideration, even if none is apparent on the record?
I think I would rely on the standard, Your Honor. If the direct appeal record conclusively established the merit of the claim, then it does, and a 440 wouldn't be required. But here, first of all, we have no idea what counsel's exact thinking was on this charge. The defendant never moved to expand the record. So, he's effectively asking for a per se rule, which is that if there appears to be cross-racial identification and that's not requested, that's per se error. And I think that's inconsistent with how this court has long evaluated ineffective assistance claims, and it's inconsistent with Boone itself. I mean, in Boone, the
Does
court.
it matter what the nature of this case was, the circumstances that identification was the central issue, when you're making that assessment?
In this situation, I think identification is always at issue. I do disagree with my adversary about the alleged weakness of this identification. I mean, we had a person who was struck in the face with a hard object, but he didn't lose consciousness. He testified that his vision wasn't blurred. The defendant.
Wasn't he suffering from some effects of the assault afterwards, at the time that he then subsequently, after the first time he thought he saw the person, then he called again? The first person wasn't then identified as a perpetrator. Then he identified the defendant on a subsequent call, correct?
That's right. He called the police when he was on 103rd Street. I believe it was on October 12th.
And at that time, was he suffering from the effects of the assault?
Your Honor, I think he may have been. He did not go to the hospital until the 14th, so it was the day after the point out. He may have been. I mean, he was ultimately diagnosed with a fractured orbital bone. However, he was given what seems to have been over-the-counter pain medication, and he never followed up with his providers after that hospital visit. But I think when you go through all of the factors that the charge talks about, all of them, I mean, counsel attacked all of them, but almost all of them support.
So again, but it says during his confirmatory identification, as you indicated, his orbital bone, that affects vision, injury caused him dizziness, headaches, facial swelling, along with forgetting things. Does that have any impact on whether or not the charge should have been requested?
I don't know if it impacts whether or not the cross-racial ID charge should have been requested. I mean, if counsel had not requested the expanded identification charge, which that question directly addresses, I think he'd be in a bit of hot water, but he did request it, and he did highlight that.
Well, that's
Did he
interesting.
ask
By bail-
questions about that
by-
during?
By bail of hot water, do you mean that would be ineffective?
No, I don't want to concede that it would have been
Well, that's what I'm
ineffective, but it would have been problematic, given that this was a single witness case. If he had not requested the charge, I think we would have been in a harder
So
position.
why not also ineffective? I understand you're not conceding it would have been problematic, whatever word you want to use, but why is it not equally problematic not to request the cross-racial charge? If it's problematic, it would have been problematic to not request expanded witness.
Well, one, it wasn't his theory of the case, is one thing. Two, I think
But
the
how
evidence.
do we, well, his theory was, I think, honest but mistaken ID, yes?
Yes.
And I would think that the challenges in cross-racial IDs that are laid out in the instruction, eventually in Boone, would be relevant to the risk of a honest but mistaken ID. No?
No, they could be. I'm not saying it's inconsistent, but his focus was directed at the other components of the one witness identification charge. And as I.
Why wouldn't the cross-racial ID charge boost his position with respect to the other factors?
Well, I don't know that it would boost it at all. It's a permissive instruction at the time, at least in 2011, that said the jury may consider the difference in race and whether it affected.
The point of the charge is to let the jurors know that for some people, cross-racial identifications are more challenging. It makes it more difficult for them to be able to make those identifications when it's someone of a different race from their own.
Of course, and I think in this case, given the
Why would
circumstances.
that, arguing everything else, simply make the argument stronger from the defendant's perspective, that here this is a misidentification?
Well, I think in this case, counsel may have thought that it wouldn't have, given the circumstances that were presented with, that I've been talking about in terms of the background of the witness and the identification procedures and attempts to locate the perpetrator that the witness went through. And
So
counsel.
is that what should be factored into these IAC cases regarding the impact of Boone, whether or not a counsel would think, by their own assessment, that the witness, whether it's a victim or some other witness, has enough exposure in early childhood to the race of which the defendant happens to be, that they would not be subject to the kinds of inabilities that is pointed out in the scientific literature?
I think those are among the circumstances that counsel can consider in whether or not they want to pursue the cross-racial identification charge, and further to not just request it, but to highlight it, develop proof on it, things of that nature.
I want to make sure I understand what point of differentiation you see between the expanded witness charge and the cross-racial charge. So I take it from your responses that you think that it would have been more concerning, more problematic, to not request the expanded witness charge than the cross-racial. Is that because then there would be nothing that gets at the theory of the defense at all? Is it because there's some evidence in the record that's relevant to one but not the other? Could you tell me a little more why?
I guess, by way of analogy to DeBellis, counsel made a lot of arguments about factors in the cross-racial identification, or sorry, excuse me, not the cross-racial identification charge, the expanded witness charge. And by way of analogy, if he had not requested expanded identification, the jury may not have known what to do with that. I don't think this case is at all like DeBellis, like my opponent, because there, it seemed like counsel's error, this court found counsel's error deprived the jury of the opportunity to consider the defense. And the counsel requested the wrong defense, and therefore the jury could not acquit if it believed the defendant's testimony and the theory that defense counsel had developed.
Can I
throughout
ask
the case.
you, as I asked the other side, does it matter that the single witness who's the victim is Latino? Does it matter? Does it affect the analysis in any way?
It could in a case where there's, I think, a dispute of whether or not there was a cross-racial identification at all. But we're not, on this record, disputing that the identification was.
No, you're not. I guess in part, my question is whether or not that could be a reason for not requesting it if counsel was not certain that this was actually a cross-racial case.
I think that would be a legitimate position for counsel to take if they weren't certain. I suppose that would be reviewable to the extent the record bore out those things.
Do you agree with appellate defense counsel, defense appellate counsel, that the record at the trial level bears out that the parties were in agreement that the victim was indeed a non-black Hispanic? I think that's the way she referred to it.
I don't think the record shows any dispute about that.
No, but does it show an agreement about that?
Not in an affirmative sense, Your Honor. I think it's unclear on that regard.
What's your view about how CJI charges should inform our ineffectiveness analysis? Opposing counsel says if it's in there, it's your obligation to, essentially to ask for it, I think, if it bears on the defense. What about you?
I'm unaware of this court or appellate division or any court really finding that counsel was ineffective solely for failing to pursue a CJI charge that's available. So I don't think that's.
Well, if it was the only charge that was out there relevant to your defense, then it might be, as you say, I think that's how you characterize DeBellis, might be more like DeBellis in that regard, no?
It could be, if I'm understanding Your Honor's question correctly, but I guess the point is, just because it's in the CJI and it's an option, not the only option, but an option, I don't think that alone establishes that counsel performed efficiently.
But do you agree that a reasonable lawyer acting on their professional duties and obligations, whether it's defense counsel or the prosecution, should know what the charges are in the CJI, at least with respect to the charges related to the case that they're working on?
Of course, I agree with that, Your Honor, but my dispute is that this record does not establish that this lawyer did not know that. And that's why one of our arguments is that a 440 should be brought to bear that out. Perhaps he didn't, but on this record, I don't think this court could make that finding. I know my light's on, Your Honor, if I might just briefly.
So if they knew, would counsel have been ineffective if they knew? I didn't think that was your position, but you seem to be suggesting that now.
No, I'm not saying that he would be ineffective, because that would be going towards prong one only. The last point I did want to make was that under Blake, and I think this case is very much like Blake in the sense that even if it was a mistake not to request the charge, it wasn't, a clear-cut and completely
Could you
dispositive.
perhaps address the distinctions counsel was drawing with respect to Blake and why she's wrong?
Yeah, well, I think like Blake, at the time of the trial, it was not clear that the charge would have been given upon request. And I think more towards the prejudice component, there's no reasonable probability that had the charge been granted, the jury would have drawn the permissive inference that the charge allows. And so I don't think, or our position is, you can't establish prejudice on this record, just like you couldn't establish prejudice in Blake. So
Thank you.
it's just further questions I asked you to affirm.
Counsel, before you begin, do you think an attorney could have decided on this record, after the victim had looked through hundreds of mugshots and was in a situation where they were brought someone and they said, nope, that's not the person, and then only on the second time they said yes, that an attorney might decide, you know, this person seems to have no problem in identification, and maybe it's something along the lines of what Judge Rivera was getting to. I don't want to highlight cross-race or cross-ethnic identifications because I think it's clear that this person is pretty discerning, and instead I'm going to focus on normal identification, expanded ID, light, distance. I don't want to insult any of the jurors. I don't want them to suggest that I don't think someone from the Dominican Republic can identify someone who's African American. I've looked at this jury. I see what they look like. I've seen the victim testify, and I'd rather go with maybe he was disoriented at the time that the ID was made. Is that not a trial strategy that at least we should explore in a 440?
The mugshots, Your Honor, are no rational reason to not request the charge. Simply not picking out someone from the photos is irrelevant as to whether they were affected by the cross-race effect at the time of the in-person street encounter ID of Mr. Watkins. No one can ever say that the cross-race effect causes people to always misidentify every single person of a different race placed before them for ID. That's just not how it works. It's more of a complex inquiry that could absolutely have come into play when Mr. Watkins was standing on the street and the complainant saw him in person, his height, something about that combined with the cross-race effect could have absolutely triggered a misidentification.
So it wouldn't even permit, say, an inference that this witness has a very fixed idea of who his assailant was in terms of the way they looked?
No, Your Honor. He gave a very bare-bones description to the police officers. He only
No. I mean, the fact that he looked at 462 other faces and said, nope, not them, that doesn't suggest that he's fairly certain that he knows who he's looking for?
No, Your Honor. If anything, it could suggest an inability to be able to discern between faces of a different race and to be more susceptible by the cross-race effect because these photos all look the same to him and he can't pick anybody out. And that's what social scientists have said.
Counsel, the other part of Judge Singus's question, couldn't this lawyer have looked at this witness and looked at this jury, especially given, as Judge Rivera is saying, the background of this particular witness, and said, I don't want to do this. I don't think this jury, this makeup is going to react well to that. Isn't that valid?
The CJI only says that you may consider whether there is a difference in race between the complainant and the defendant. So this is a fact for the jury to decide.
Right, but let's
in
say
the end.
the lawyer in that courtroom reads this jury and says, maybe there are many with a similar background to this witness, this victim. I don't want to ask for this charge. I think it's offensive here. Maybe they're going to find it that way. Can a defense lawyer read the jury that way?
As this court articulated in Boone, a trepidation to talk about race is no
It's not a
excuse to
trepidation
not.
to talk about race. It's that I'm looking at this jury and I'm saying, this jury I don't think is going to be particularly receptive to this charge with this victim witness.
Regardless of the races of jurors or anyone, this is an important tool that was kept
So
from
that-
the jury in
Then it would be
assessing.
mandatory under Boone, right? And we didn't say that. We said that the lawyer has discretion whether to ask for it, which seems to be somewhat eroded in your argument. But, so where's the discretion then? When would you ever not under your theory?
Well, Your Honor, if misidentification's not the defense theory, then of course the lawyer's not going to want.
Anytime you're saying it isn't my guy, then you have to ask for this.
Yes, Your Honor.
Okay.
Yes, for the most part. I mean, it's not a per se rule necessarily, but in this fact specific, in cases like this,
Boone
that are
is
so.
very clear. It's, I mean, what I'm grappling with is, it seems to me Boone is clear that it's discretionary. And I'm not sure that Boone is saying it's discretionary if your defense is not mistaken ID, but it's not discretionary if your defense is mistaken ID. So given, if I'm reading Boone correctly, and Boone holds that it's discretionary even when your defense is mistaken ID, then there have to be, I would think, some circumstances where defense counsel could permissibly decide not to request the charge.
Certainly, Your Honor. It's just not this case. In this case, it would not have been appropriate, and in cases similar to this, possibly, it would also not be appropriate to decline to request that charge. And this court giving,
Well, under Boone, the charge is not available if identification is not at issue. And it's
That's
not available because Boone is limited to cross-racial ID if the witness and the defendant are not of different races. So that is the only time that Boone has identified that the charge is available to the defendant for its request, and then the court does have to give the charge. Does it matter that that it's a charge? It's the court giving the charge? The lawyer need not get up and refer to it.
absolutely, Your Honor, for the judge to mouth those words and for the jury to hear this coming from the judge gives them that perspective to analyze this case and to doubt the identification even more. And in Boone, this court said that 47% of jurors don't know
Let's
about
say
the cross race.
There's a 440, and this defense lawyer gets up and says, under oath, I looked at this jury, I looked at the background of this witness, and I thought this would not be a productive charge for me in getting my client off to ask for that charge. That is per se ineffective. He can't think that.
Your Honor, I don't know all the specific facts of that case. It would not necessarily
Well, we
be
don't know
per
because we
se.
don't know what the defense lawyer in this case would say. But let's say the defense lawyer in this case, in a 440, gets up and says, I looked at this jury, I looked at this witness, I looked at the cross-racial ID charge, and I thought, it's going to do more harm than good for me with this jury, and I decided I didn't want to ask for it. That would still be ineffective.
That would be, Your Honor.
Thank you.